Thank you, Madam Chairman, and thank you to each of the distinguished members of the panel for being here today. I want to start, Professor Thurmstrom, with asking you a question, which is, am I correct that the Voting Rights Act, and in particular Section 2, remains on the books as strong protection against discrimination in voting?
Well, of course you're right. And, oh, I'm sorry, I didn't have. Of course you're right, absolutely. And I mean, the counter argument is close to incomprehensible to me.
Well, and I want to make sure that everyone observing this hearing understands what the focus is. The focus is one particular portion of the Voting Rights Act, Section 5, which subjected a handful of states to unique scrutiny. And I'd like to ask Mr. Carvin a question of you. Under Section 5, elected state legislatures in the states that were singled out, before they could enact any laws concerning voting, had to receive the prior approval of unelected federal bureaucrats in Washington. The Supreme Court has called that system extraordinary. But my question is there any other area of law where elected officials in states have to come to the federal government to ask unelected bureaucrats their permission before carrying out their duties in the legislature?
No, there's not. And the court in 1965 and Katzenbach and all the others has recognized that this is not only a reversal of the traditional Anglo-American jurisprudence presumption of innocence, but you are literally suspending states' rights to legislate in a particular area. The federal sovereign is telling them, no, you cannot do it until you come on bended knee and a unelected official says, okay, we will allow you to do it. There's been a lot of conversation today about the bipartisan support and the importance of Voting Rights Act, and yet the basic premise of Section 5 preclearance is that elected representatives are incompetent minors who are literally incapable of arranging electoral systems, even though, as you know, the Constitution left the question of voter qualifications and most important aspects of running elections to the states quite consciously. So it is not only unprecedented, it certainly pushes the outermost boundaries of our federalist system and was only justified in the 1960s as a acknowledged temporary exception to the normal rules because of the extraordinary situation that existed in the Jim Crow South.
And I would note, Mr. Carvin, you and I have a long history together. We practiced law together, and indeed, we both were involved in litigating a prior redistricting case in the state of Texas, where I was representing the state and you were litigating as well, that went to the Supreme Court and ultimately prevailed at the Supreme Court. I want to understand, and I want people here to understand, how those unelected bureaucrats of the Department of Justice have used this authority. Is it not the case that the Department of Justice has taken the position that Section 5, and indeed Section 2 as well, protects the ability to elect Democrats? And indeed in Texas they took the position that Henry Bonilla, an Hispanic who was elected, was not protected. However, Lloyd Doggett, an Anglo-Democrat, was protected, and the difference between the two was that one was a Republican, and therefore that Hispanic elected official was not in the ambit, but the other, a Democrat, was. Is that correct?
Yes, that's exactly what happened in Texas, and I think it's important to focus on the fact that under the new ability to elect standard enacted for the first time in 2006 to overrule Georgia v. Ashcroft, the Justice Department and certain courts have taken the position that any effort to diminish minorities' ability to elect white Democrats is nonetheless violative of Section 5. So you literally have a federal law that says you can't hurt the ability to elect white Democrats, no matter how compelling the demographic or other justifications are.
Thank you, Mr. Carbon. I'd like to ask a final question of Senator Garcia. I find it interesting, you and I are both at this hearing. We are both elected officials in the state of Texas. We are both Hispanic. And indeed, Texas has a record of electing substantially more Hispanics and African Americans statewide than almost any other state. And yet what this bill would do, and it is interesting to see a number of Democratic politicians, many from the Northeast, suggesting that Texas needs some sort of special scrutiny. Although the record in Texas of minorities being elected is better than most other states, and indeed the turnout numbers in both the African American community and the Hispanic community is better than many other states. In your experience as an elected official in Texas, serving in the legislature, do you believe that elected officials in Texas are somehow substantially more deficient than elected officials in other states across the country?
Well, I don't think so. You know, we in Texas think that we're the best no matter what it is. But I think...
I agree with you in that regard.
Well, thank you. You know, the Senate Hispanic Caucus has wrestled with some of these issues, and I can tell you that for us it's just as stressing, and I'll repeat the numbers. In 2010, we were 42nd in registration as a state. We were 51st in voter turnout. I mean, those numbers are just not anything to brag about, although we'd like to brag about many things. And if you look historically at our record, if we've had 107 Section 5 violations between 1982 and 2005, again, that is nothing to brag about. So if you look at the immediate history, and then if you just, my written testimony goes through all the history dating back to the 1800s. There has been historic discrimination in the state of Texas. Regrettably, it's still there.
But Senator Garcia, if I may briefly, and my time is expired, so if I just may briefly ask one final question. If you look at the data, for example, from the 2012 election, in 2012, African American voter turnout in Texas was 10 percentage points higher than white turnout in Texas. And in fact, if you look at the states in 2012, where turnout was worse, where there was a greater differential, the following states have substantially worse numbers than Texas. Texas has among the best numbers in the country, but you have Washington State, Colorado, Kansas, Arizona, Minnesota, Massachusetts, Delaware, Arkansas, Minnesota, Florida, Kentucky, Connecticut, Virginia. Those are all the states where white turnout was higher than African American turnout. In Washington State, it was 18.5% higher. Now, Washington State is not covered. Texas, on the other hand, African American turnout not only was not lower than white turnout, it was 10 points higher. And with that record, and I would note among Hispanics, the Hispanic record is also markedly better than many other states across the country. What justifies singling out Texas and a couple of other states for some sort of special treatment when the record is markedly better in Texas than in many other states?
Again, I think it's because of the history, and it's about some of the things that have been going on in our state. I think when you look at, I mean, I'll give you a perfect example. I mean, I filed a bill so that when anybody turns in a voter application, if it gets rejected by the voter registrar, that simply the person be simply told by letter, you know, your application was rejected because you forgot to put your date of birth or you forgot to put your full address. That was rejected. So once it's rejected in terms of a bill that we can't put in place to protect the voter till they'll know why they were rejected so they can register to vote and make sure they gain access to that ballot, that's just not good for us. I mean, we need to be doing everything we can to improve access to the ballot, to make it convenient and to make it easy so that we can have full participation. If we've increased, that's great, but I know our state is great. We can even do better.
Thank you very much.
Thank you.